Could you please introduce yourself for the folks that are watching?
Yes, my name is Ronald Holloway. I am chairman of the New Jersey Sandhill Band of Lenape and Cherokee Indians.
Chairman Holloway, could you please explain what occurred between your tribe and the state of New Jersey that caused you to first seek relief through the federal courts and now through the United Nations?
I can. If you go back far enough, 1801, 1802, the de facto state of New Jersey passed illegal legislation or statutes that enabled them to take and sell off lands that were not theirs and to strip us of our hunting and fishing rights. More recently, in the last few years, after attempting to establish a dialogue with Governor Corzine and his staff, we began giving presentations to the New Jersey Indian Commission, hours and hours of presentations, and we delivered more than 100 documents, not only to the Commission, but to the Attorney General's office through various Deputy Attorney Generals, only to be stonewalled and rebuffed over our complaints, to be ignored. After considering which way was necessary to proceed, we decided that the federal courts were probably the best venue. If you're familiar with recent events, you see the sweeping arrests that have been going on in the state of New Jersey of politicians. And when one listens to the Justice Department's view of this, saying that this is only the tip of the iceberg, you begin to understand the internal mechanisms of the state of New Jersey, that there is a problem with corruption and being ensured that everybody has equal access to the law and to the politicians. Some people are a little more equal than others. So when we analyzed that state judges are appointed by state politicians, we realized that probably the most important venue was the federal court system. We took advantage of 28 U.S.C. sections 1331, 32, 1345, 1362, which ensured that as a sovereign Indian nation, we were entitled to bring any case before the federal courts that the United States, acting as trustor, could have brought in our stead. We filed these cases, these petitions, with the federal courts. However, they were not designed to be heard in district court because of their constitutional nature. They were supposed to be heard by the closest three-panel court, which is the Third Circuit in Philadelphia. However, the courts reserved to themselves, through reverse implication of the law, that they reserved the right to review the cases before passing them on, even though the law said you file there and it goes here. They used the fact that the filing reserved the right to them to hold on to the case. After being bogged down for quite a considerable amount of time with motions that haven't even been answered, time limits being extended for the defendants to refile after they were already in default and default motions had been filed, and having all of that ignored, we decided it was necessary to go to the United Nations to establish a more level playing field where people are concerned with the substance of the allegation and the genocide charge is not concerned with trying to beat you on a period or a semicolon. I spent time when I was younger as a police officer, and it used to infuriate me as a cop. You arrest these people, you bring them in, and a lawyer gets them off because you missed a word in something, or you didn't write the report. And that's what we saw happening, a deliberate bogging down, a media blackout. Everything was being done to suppress this case, and we needed to have somebody to take a look at it who was unbiased and not subject to the internal pressures and corruption that exists in the state of New Jersey.
Is that treaty still viable?
Oh, without a doubt. From an international law standpoint, yes, but also, more importantly, from a U.S. standpoint. The way it works according to the Supreme Court is that the Congress of the United States is the only body in this country that can cancel a treaty. And it can't be done ambiguously. Congress has to set out with the intent in the specific language saying, we are canceling this treaty, we are no longer going to honor it. Without specific congressional intent, the treaty is still in effect. And Congress has never even addressed these treaties, which they grandfathered in at the end of the Revolutionary War and codified basically under the Trade and Intercourse Act of 1790 and 1792 and the subsequent acts, which are just expanded versions of the 1790.
How would this impact the state when you win the suit?
Well, it would be sweeping. Technically, if you take a look at the quitclaim deeds, the original configurations of the reservation and the rights, we would have hunting and fishing rights throughout the state from the north to the south. We would also have unfettered fishing access to the coastline between Port Elizabeth and the Delaware Bay, extending 2.5 miles out from the low water mark. Also, the Delaware River from roughly parallel to Trenton as it opens up into the bay, most of Wharton State Forest, as well as the aquifers that exist underneath the land, and all peripheral rivers, lakes, streams, and runs. So rather sweeping.
Could you please summarize the original complaint as it was filed in the federal district court back in February?
The original complaint consisted of 13 counts, some of which were genocide, crimes against humanity, violations of the 1964 Civil Rights Act, violations of the 1871 KKK Act, Ku Klux Klan Act, violations of the Jay Treaty, the Treaty of Ghent, illegal restrictions on travel, which we were guaranteed, illegal taxes being levied upon our people, of course the eviction from our lands, and the fact that the state of New Jersey wasn't a state when they did it.
And why did you have to file an amended complaint?
Long and short of it is we won. We went into the scheduling hearing and there were 9 defaults on the board, including Governor Corzine individually and Secretary Wells, who weren't bothered enough to even have answered the complaint themselves. As a matter of fact, they delegated it to a Deputy Attorney General, I think her name is Hale, to answer for them because they were entirely too busy to be bothered. But long and short, there were 9 defendants in default, and Magistrate Schwartz decided to extend the time frame to give them another couple of months to answer, to which naturally I objected, but it was overruled. It was felt it was in the best interest of the case. So in a subsequent objection, I requested that if the state is going to be given another 60 days to figure out how to answer, that we should be given the opportunity to amend our complaint, given an extra 60 days as well. And the judge granted that over the objections of all those attorneys that filled up the jury box in the overflow.
Have you heard from any of the counties seeking a meeting in an effort to negotiate the issues and in an attempt to settle the matter?
Well, that's a resounding no. I mean, I have called myself and talked to each council and called each county council and all their hired guns at one point or another. And to this point, no. As a matter of fact, at the last hearing, each and every lead council stood up and when asked the very same question by Magistrate Schwartz, they said, no, not only have we not spoken with him, we're not going to. So it's not on, from our standpoint, we always want to talk. If dialogue had happened years ago, it wouldn't be a problem.
If you did hear from them, would you be willing to negotiate?
Yes, I think it's in the best interest of all parties to figure out some way to coexist. It's intrinsically wrong to come in and steal somebody's land and then pretend they don't exist. And all of this that we're seeing as a result, the additional court actions, additional filings, and now the UN filing, is a result of the fact that Governor Corzine and Secretary Wells and, of course, Attorney General Milgram have refused any dialogue whatsoever. So we're being forced into each successive step.
Could you explain why the date of the ratification of the state of New Jersey's Constitution back in 1844 is pertinent to this case?
As a matter of law, it should be pertinent to everybody in the country. Basically, a state operates the same as a corporation. If you have a business, you have a business charter, your corporate charter, which outlines how you can work and the shareholders vote for it. A state is no different. Originally, there were 2 business grants to the United States, which were eventually subdivided and became what's known as the 13 colonies. The state of New Jersey did not ratify their constitution until 1844. So we run into a situation of, and that's why you notice in the filing that I use the term de facto, because you have a form of government that is operating as such but without the force of law. Without a ratified constitution, the state does not have the legal authority to have passed statutes, which is what they did. They passed a statute in 1801 to take our land in 1802. But